Good evening, everyone. Good evening, friends and colleagues. Hello, can you hear me? Oh, moderately. Can we have a bit more volume? Do we need more volume? It's fine. Is that why? Oh, should I do this then? Okay, I'll do this. Is that better? Right. Thank you, Jeff. Welcome, everybody. It's lovely to see you. Welcome to our professorial inaugural lectures for 2023. I'm Chris Greer. I'm Pro-Vice Chancellor Research at the University of Essex and a professor in the Department of Sociology, and it is wonderful to have you here with us in person tonight. 2023 marks the 10th anniversary of this prestigious lecture series, and these lectures are a highlight of our academic calendar, giving us a chance to come together to celebrate the world's leading research talent here at the University of Essex. Since 2013, we've been inviting our newly appointed professors to speak about their work to an audience of members of the public, our students and staff, alumni, and invited guests. We hope we will inspire you by giving you an insight into our world-class research across the social sciences, science and health, and tonight, the arts and humanities. Please keep an eye out for upcoming events in May. Having both Professor Onyeko Suji and Professor Matthew Stone from the Essex Law School with us here tonight means you will have the chance to hear from two outstanding academics from Essex Law School in our Faculty of Arts and Humanities. Essex Law School has a stellar international reputation, and we're recognised as third in the UK for research power in law, according to the Times Higher Education. That is third in the UK for law, which is a fantastic achievement, and a great testament to the impact of our law research and the size and diversity of the academic community at Essex Law School. Across our three faculties, our community of almost 800 Essex researchers are change makers, innovators, and free thinkers. They pose bold questions, tackle real-world problems, shape thinking, and influence policy. These professorial inaugural lectures are designed to inspire and perhaps challenge through the celebration of our excellence in research. You'll see all the qualities of our unique Essex research mindset demonstrated by the world-class academics speaking tonight. After the lecture, I hope you'll take the opportunity to ask questions, and then you will be very, very welcome to join us for a drinks reception, where you'll have the chance to speak further with the professors and each other. I would now like to hand you over to the Executive Dean of the Faculty of Arts and Humanities and a Professor in Essex Law School, Andrew Le Sueur. Thank you.
Thank you very much indeed, Chris, and I would like to welcome everyone on behalf of the faculty to the lecture this evening. And my welcome is extended to those of you who are joining us via our live stream on YouTube. And whether you're in the room or online, thank you so much for joining us this evening to celebrate our colleagues' achievements. As Chris Greer noted, Essex Law School has grown into a national research powerhouse. The 2021 Research Excellence exercise puts Essex Law School ranked third in the country for research power, which measures research excellence and capacity. And in the Times Higher World University rankings, the school is positioned in the top 50 globally, recognising its reputation and international orientation. And these external measures reflect the depth, breadth, and significance of colleagues' research activity. We encourage our students to develop an international outlook, to understand cross-cultural perspectives, and to gain a research mindset. Many students are directly involved in social justice projects through our outreach work, volunteer projects, and our human rights clinic and Essex Law Clinic. And many of us in our research are also keen to improve people's lives as we respond to local, national, and global issues and the changing challenges that people organisations and business face. And our two speakers this evening really do illustrate the diversity of expertise within Essex Law School. So first to introduce the Dean of Essex Law School, Professor Onyeka Asuji. Professor Asuji joined Essex in 2017. He obtained a PhD in law from the University of Manchester, a BCL from the University of Oxford, and an LLB from the University of Nigeria. Before becoming an academic, Professor Asuji practiced in corporate and commercial law. His research and published writings are in the areas of corporate governance, corporate social responsibility, globalization, regulation, consumer protection, social and non-financial reporting, banking and asset management, and multinational enterprises. Professor Asuji, the floor is yours.
Thank you, Andrew. Thank you, everyone. My family, they seem to have disappeared. Okay. Friends, colleagues, everyone, thank you for being here. Let me talk a little bit about why I chose the topic. I have two lovely children here. Sometimes I hear some noise upstairs, and what's going on? And I hear, I'm told, Daddy, we are playing a game. What it tells me is actually a code. Don't interfere, don't intervene, don't come between us. We're playing a game. And I also happen to have, a lovely wife, a great mother to my children. But once it comes to games, she doesn't allow them to win. It's a game. Okay, so, and when I was thinking about the topic for the lecture, I went back to this particular statement by Milton Friedman. The statement was made in a newspaper article in 1970. It's a newspaper article. He made a reference to his book on capitalism and freedom and described social responsibility as subversive doctrine. That businesses should only be concerned with profits and only profits, but with the caveat that they have to engage within the rules of the game. And that takes us to some of the debates. They've been there since time immemorial, and they're still ongoing. What is the role of business in society? And to answer this question, I know some people would say business is all bad. Some would say it's all good. I'm somewhere in between, maybe because of my previous professional legal practice. I helped to set up businesses. I discussed with business people. I knew what they wanted to do in order to change lives, maybe make a bit of money on the side. But in the course of practice, I also remembered two examples. I remember a multinational tobacco company going inside a room to discuss investments. It turned out to be a tobacco company. I started asking myself questions. What is good about tobacco? And not just that, I realized that the tobacco company was so powerful. The lawyers, government officials, regulators, everyone was doing what the tobacco company wanted. So that was my experience before I became an academic. So when you look at the question or the point made by Friedman in 1970. A long time ago for many of us, but the reality is it is still subject of debate today. People still talk about it. On the one side, you will see people saying, in favor of Friedman, saying things like, yes, businesses need to make money because making money is good for society. They invest, they create employment and all that. Then some other people would also, on that side, argue it's not good to focus on money. Then a third group will be saying things like, but Friedman made a reference to rules of the game. Open and free competition without deception or fraud. So in other words, Friedman is not really making a bad point. But my question is, what are the rules of the game? So people spend time, okay, is it pro-corporate social responsibility? Is it a pro-good contribution to society statement or bad? But the question is still, what are the rules of the game? And to look at it, let's go back to what a game is. I've got that picture there. It really happened. There was a football game. Just to let you know, my other life is about football. Okay? So it's a football game in China. It was won by, the competition was won by a South Korean team, under 18 team. They won the game in the field of play. Then afterwards, to celebrate the winning on the pitch. So that's the picture there. So one of them put his foot on the top of the trophy. And the result was that they were told that's not part of the rules of the game. It was considered insulting, particularly in Chinese culture, to behave that way. And they were stripped of the title. So the question is, the reference to the rules of the game in Friedman's statement, is it like my children would say, don't interfere, this is our private affair, it doesn't matter, none of your business. In fact, it doesn't matter to society, it doesn't matter to me. Or is it something beyond that? So the rules of the game we're talking about here, in football, anyone interested in football knows about football, or any other game, is it just about what is written down? What happens in the field of play? Between the teams, what about the spectators? What about countries, like in that picture? What about different cultures? What about the fans? What about employees? What about the local community? And if you follow football, like I follow, you will understand that the rules of the game are not actually constrained to what happens in the field of play. You go beyond that. So that takes us to the next question then, to understand where the statement should be contextualized. What are the rules of the game in terms of today, in terms of business and governance? And I think the first one is to look at the underpinning philosophy. And the first you can see there is lifeboat ethics. If you look at the picture here, on the far side, you have the poor people, poor countries, poor communities boat. On the near side, you find the rich people, rich communities boat. According to lifeboat ethics, the rich peoples, the rich communities boat, the space is restricted, and for the poor people's boat, you have a lot of people struggling a lot of them on the water, trying to avoid drowning. They want to get onto the rich people's boats. But if the rich people allow the poor people to get in, what happens is that the rich people's boat will also have problems, and they are likely to suffer. And in fact, no one will survive. So, in other words, the lifeboat ethics is you focus on your self-interest and your self-interest alone. And you should not be interested in what happens to the rest of the world. In fact, we should not help. The philosophy was postulated by Hardin in 1974. And if you go and read Friedman's Capitalism and Freedom, you will see the connection there. And his reference to fundamentally subversive doctrine in reference to social responsibility is a nod to that lifeboat ethics. So that's the first one. The second point is that the rules of the game being referenced in that statement, here they are referring to neoliberal ideology, the idea that the government should not interfere. As less interference as possible is what is required. And that is what the point about capitalism and freedom. The idea that with freedom, you make more money. And it's good for society to allow that sort of freedom. So that's another underpinning ideology for the rules of the game being made reference to. But what we can see is that in reality, the neoliberal ideology has created disparities in the global community, even in local communities. So that's the second point I want to note. Now, moving on. So looking at the ideological underpinning, the philosophical underpinning, so let's look at company law, which governs businesses. Company law also reflects that self-centered approach. If you look at that case of Dodge and Ford Motors, people will reference it where a court in the US said, a business should not make donations to universities because that's not part of the business. The decision was sort of overruled by subsequent cases, it seems, but the principle is still, whatever you do should be for the interest of shareholders, not for any other person. So if you are doing good, you should be doing good for the purposes of your financial bottom line. So that is still the principle in company law, in the Anglo-American corporate governance tradition. And that's why we have some of these cases saying that the company is always the shareholders. That is another way of saying that companies should not be interested in anybody else but profit making for shareholders. So that is the rule of the game, or one of the rules of the game. So the third point is the notion of externalities. The idea that as part of corporate or business activities, there are some fallouts, some consequences which are not borne by the business, but actually suffered by society. So look at the example of gas flaring there. The business can expel the gases, it harms the rest of us. They make the profit. That's an example of externality. And you'll be thinking, is that how it works? That's true. Let me give an example with tobacco. When people smoke, ask anyone who works with the NHS the impact of smoking, how much it costs all of us paying taxes, not just the impact on families, but who takes care of that cost. So what we see, essentially, from that case of tobacco, for instance, or the banks, is that the rules of the, or one of the rules of the game is that harms, losses are privatized. Harms and losses are socialized, so the whole society can bear those costs, whereas profits are for the business or the business owners. So that's the other part of the rules of the game. Then the other aspect is there is no room for recognizing or protecting the weak in the rules of the game. And that is the fact. Let me use the example of that Leonard and PepsiCo to talk about advertising and marketing and competition. Some years ago, I used to teach contract law, and I used this case to illustrate a different principle that not all statements should be believed. What happened in the case was a consumer saw an advert by Pepsi. You remember, Pepsi is a rival to Coca-Cola. So the consumer now saw the advert, and adverts sort of showed that if you get a number of tubs of Pepsi bottles, you get a military jet, a big one, those very expensive ones. And this consumer managed to get the number of tubs or so needed and asked for the reward. The case went to court. And the court said, look, you should not believe everything the business says. That's not how it works. But what you can also see from that case is that this is encouraging people to drink as much processed sugar as possible. And no one talked about it. And you see it happening. This is a US case. You also see it happening in several developing countries. So that's one of the rules of the game. And the other aspect of the rules of the game is with regards to formulation and enforcement of rules. If you look at the picture there, that explains it. That essentially, the reality, ask anyone connected to public policy making. Public policy making is about competition between different social actors in society. And the more powerful ones determine the public policy. And who are the more powerful ones? The businesses, most times. The example I can give there is that case of Kasky and Nike. So some people found a loophole in the law to challenge a business statement about being good. The case went up all the way to the US Supreme Court and was later settled. What happened afterwards? This is California. People know California is so liberal, so protective of people. But immediately the California lawmakers changed the law, meaning that you cannot bring such claims again. So that's one of the rules of the games there. You can advertise, you can do whatever you want, but the reality is you determine the rules. If for some reason the rules don't favor you, you can also change it. Those are the rules of the game. Then the third or the last component of the rules of the game is corporate social responsibility, the voluntary aspect. So if you complain about businesses not doing well, not doing good, it's easy to bring corporate social responsibility as an answer. We have this concept. So allow us because we are doing good. But the reality is that some of the businesses, or most of them, that actually shout corporate social responsibility in the pure voluntary form are the worst in terms of social performance. So that is that. So I've actually tried to articulate what the problems are. So what are the solutions? The first one is to connect business to governance properly. And to do that, I've proposed 5 different things to do. I'm going to look at them quickly. The first one is to see businesses the way we see individuals, as part of society. So you have a role to contribute to society. If you have the power, you contribute. You have the role to make sure you don't harm other members of society. So that is the first principle for me. The second one is to also understand that the notion of business responsibility can be context specific as well as universal. So it means that if you go to a particular place, you can look at the needs. You can also avoid exploiting loopholes. You can also avoid exploiting institutional weaknesses if you want to be seen as a good business. So that's the second point for me. The third point for me as well is, as a business, you have to use your power, your influence for good. So if you are powerful enough to influence other businesses, if you're powerful enough to even influence governments, international organizations, you should be able to do that. You should be asked to do that. So business gatekeeper responsibility, that is the third point I can mention as a solution. Then, this one comes closer home for me in terms of my research. This is to see corporate social responsibility not just as a pure voluntary concept, but as a tool for governance. And what does that mean? First is to see that there is a complex relationship between corporate social responsibility and law. Law can help corporate social responsibility to be stronger, to be more effective. I've written a few things in that area to try to show the connection between the two and not to see the two as so divergent. So that's another point to note. I'm not going to spend a lot of time here, but it's just to show that some kind of picture to show the complex relationship between law and corporate social responsibility. There are different ways law can help to make corporate social responsibility more effective despite it being voluntary in nature. I think the last point here, with regards to my proposed solutions, is that the law should facilitate effective enforcement of the rules of the game. So not just stating what the rules of the game should be, but also helping to ensure the rules of the game are enforced. And to do that, first is to see a connection between responsibility and accountability. So if there is responsibility, you are asked to do something, then there should be accountability. Accountability should mean you have to have an audience you answer to. You also have to know there are consequences attached to that duty or obligation to do some good. But as I've talked earlier, if you leave that to public authorities alone, that's not an effective way of doing it. So to help out, there should be a stakeholder approach to enforcement, including private and public stakeholders. So that's one. And the last point there is there should also be rules in place to ensure that there is credibility of business commitments. So if a business is saying, I am socially responsible, part of the enforcement mechanism is to make sure that what they are saying can be enforced. If they are misleading people, whether it is in terms of their environmental activities, whether it is in terms of advertising, consumer protection, whatever, then there should be room for stakeholders to challenge those statements. So, in conclusion, I've tried to go into different areas, but in conclusion, does it actually matter? All I've been saying, it does, because the way you articulate issues, the way you explain what the problems are, can determine people realizing that, hey, we have a problem. Hey, these are solutions. Let me use an example of tobacco that I mentioned earlier. If people understand that tobacco business causes externality in terms of the NHS, for instance, in terms of families, in terms of those of us taxpayers who fund NHS. So it can mean that as part of ways of regulating the business, you may start thinking, how much does it cost NHS to treat tobacco patients? Who is going to bear the cost? Tobacco companies. You see that connection? So the way things are explained or talked about can help. Another example, banks. So now we've forgotten about the global financial crisis. We've forgotten about all those crises going on. Now the issue in government now is, oh, you should not regulate, you should not do anything. But once we get back to the one crisis, we come back to, oh, bailout. So if you understand the issue of socialization of harms and losses, then when someone says no regulation, you can remind them we have to regulate because we cannot simply allow socialization of harms, socialization of losses, without also requiring regulation, intervention by government and by stakeholders in what you do. So this is where I'm going to end it. And like I started, I have to say again, thank you. Thank you so much for listening. Thank you.
Onyeka, thank you so much. As someone who knows nothing at all about football and is not interested at all in football, you gave a rare example of an illustration taken from the game that I could actually understand, and I thought that was very effective. We're going to have an opportunity for questions and comments in a little while, but before then, I would like to introduce our second speaker this evening, Professor Matt Stone. Professor Stone joined Essex as a lecturer in 2011. He holds an LLB from the University of Warwick and a Master's in Research and a PhD, both from Birkbeck. Among many leadership roles, Professor Stone has served as head of school and director of education. Professor Stone's research explores the relation between law and subjectivity. In particular, the way that law shapes or challenges the way in which we understand ourselves. He has a long-standing interest in ethical forms of subjectivity, particularly those that escape the logic of modern legality. Professor Stone teaches on modules covering equity, property law, and legal theory. He's the author of a monograph on law and the ethical philosophy of Emmanuel Levinas in 2016, which has been recognized as a major contribution to the discipline. A further aspect of his research concerns the significance of property, ownership, and ideology in the way we perceive the self and the role of law in articulating propertied forms of subjectivity. Professor Stone, over to you.
Thank you, Andrew, for that very nice introduction. And thank you, everyone, for being here. It's lovely to see you all. As Andrew mentioned, I have been at Essex since 2011, when I joined as a lecturer. And so I want to sort of indulge my moment at the lectern for a moment to say a very sincere thanks to the colleagues, many of whom are here this evening, who have supported me and helped me getting to this particular talk this evening. I also want to thank, it would be wrong of me not to thank my parents who are in the audience here. I'm going to point them out. They've been providing support from a little bit earlier than 2011. They were worried that they might embarrass me by coming to my place of work, so I wanted to sort of turn the tables and embarrass them a little bit. So thank you, and thank you also to my partner, Victoria, who I can't see. Oh, there she is at the back, for your love and support over the years as well. So thank you. It's a bit cheesy, but I'm very proud to be giving this lecture, but especially proud to be giving it here at Essex amongst friends and colleagues. So, how do we do this clicker? There we go. So onto the topic of my talk. Why are we obligated towards each other? This is, of course, a very grandiose question to pose oneself, especially very grandiose to presume that I'm going to be able to provide a comprehensive answer during the course of my talk. And I know that there are some non-lawyers in the room, so I'll try not to alienate people with too much legal technicality. But my talk is about a particular source of obligation, a source of obligation that we find instantiated in law, but also through the wider history of ideas. And that's the obligating nature of conscience. That's what I want to talk about this evening. And before I get into the law stuff, I just want to dwell for a moment and invite people to think about what they imagine conscience to be. I think conscience feels, I'd suggest, a bit like an intuitive concept, something that's familiar. It's a bit like justice or injustice in that we might not instinctively know how to define it analytically, but it nevertheless feels familiar. It's the sort of thing that we might not be able to define, but we know it when we feel it and when we see it, and so on. So I'd suggest that the sort of things that we might conjure in our imagination around conscience could be things like guilt, or perhaps some sort of gravitational force in the self or acting upon the self, drawing us towards some sort of ethical ideal of how we should behave. Perhaps also the idea of having a little voice on our shoulders, counselling us as to what we should be doing in any given situation. So I want to present a particular image of conscience. This is an image of, I think, one of the greatest thinkers and cultural icons of the last few decades, is of course, Homer Simpson. Familiar sort of image. Homer has probably caused some sort of hilarious calamity. He's suffering the pangs of conscience in this particular moment. And the reason why I present this image isn't just to get a bit of a cheap giggle at the start of my talk, but I think there's also something quite interesting about this, which is if you look at this poor despondent Homer Simpson, the little voices on his shoulders are little versions of himself, which poses a sort of an interesting question about what we mean by conscience. On the one hand, they are part of him, they're an expression of him, they come from within him, they resemble him, but also they're separate from him. They're outside of his body. They have a voice that's somehow his voice, but a voice that's separate, a voice that he can hear in resolving his ethical or conscientious quandary. Okay, so that's the first point. And hopefully I'll try to sort of unravel and unpick that complication about conscience and link back to that a little bit later. I also want to just dwell for a moment in thinking about what we mean by an obligation. Again, this idea I'm talking about is conscience as an obligation. When we think about obligation in domestic English law, we tend to think about the archetypal forms of obligation being contract, and tort. I'm obligated to keep my promises in contract. I'm obligated to maintain a duty of care to those around me who might be affected by my actions in tort. What I want to talk about today is a different area of law, one that's not typically associated with conscience in that archetypal way, and that's the law of equity. And thinking about how conscience permeates this branch of law called equity. I imagine there's plenty of people in the room that are unfamiliar with what equity is. There'll be plenty of people that have studied equity and have happily purged it from their minds, I'm sure. So don't worry, I'm not going to go into a big comprehensive bit of exegesis about the various mechanisms, rules and principles of equity, but I want to suggest that there is a basic idea behind equity, which is there might be certain situations in which it's technically permissible for us to act in a particular way, but our conscience obligates us to act in a different way. And equity has a jurisdiction in making us accountable for this conscience. I'll give you a very basic example. So imagine someone mistakenly transfers a sum of money into my bank account, and I realise that it's a mistake. I realise that I'm not meant to have this money. I haven't committed a crime. The money is in my account, it's in my name, and I don't have any contractual obligation to give it back. I don't have a contract. It's not presented as a loan, but I am obligated to give it back, and it's equity that obligates me to give it back. And the way in which the language of equity justifies that obligation is that my conscience has been affected. It's the fact that I know I'm not meant to have that money. I'm aware of the mistake. And the case law in equity will literally talk about it in those terms, that one's conscience is affected and therefore one is obligated. And I think it's interesting to think about the imperative voice of equity here, the normative voice that justifies its jurisdiction. It's a bit different to criminal law. I'll say a little bit about criminal law, and I'm going to be generalising and reductive, and sorry for the criminal law experts here. But I would suggest that the imperative voice of criminal law is to say, you can't do that because the law says so. The state says so. Society says so. Equity obligates us in a different way. I'd suggest the imperative voice of equity is to say, you must do this because your conscience says so. You know that you ought to do this, or you should know that you ought to do this. You should know why you need to return that money that you've received in error. And it's important not to overly valorise equity. I mean, this sounds like a nice idea. Conscience is infused into English domestic law. Being accountable to your conscience, that sounds like a nice idea, but it's important not to valorise equity. For those who have been teaching equity and trusts, or studied equity and trusts, you'll be aware that the case law is full of stories of wealthy families squabbling over inherited wealth, or business actors disputing ownership over particular commercial assets. Nevertheless, conscience underlies the jurisdiction of equity. This is a really early statement, it's a very famous statement of the importance of conscience, that the office of the Chancellor, this is the jurisdiction of equity, in other words, the Chancellor oversees the jurisdiction of equity, and the role is to correct our consciences, to hold us accountable to our conscience. Okay, the next thing to say is that conscience is also quite an odd concept in law, in that it doesn't have a comprehensive, encompassing juridical definition. We've been talking about conscience in equity for literally hundreds of years, and yet people like me are still talking about it in 2023 because of that opacity, that ambiguity about what it actually is. And I'd suggest that perhaps a reason for that opacity and ambiguity can be traced to the way in which equity brought conscience into the legal system historically. So in the pre-modern period, the first courts of equity were effectively ecclesiastical courts. The chancellor would know what is in good conscience or bad conscience because of their privileged position in being able to understand the word of God. In fact, the chancellor adjudicating that case is understood as having a distinctly confessional role, in the same way that we might go to confession to relieve our consciences if we were of that particular religious disposition. Which is another interesting point about conscience, which is that equity obviously seeks to remedy wrongs that have been caused by behaviour in bad conscience, but it also has a role in alleviating the burden upon the particular unconscientious person. It relieves their guilt, and we find that in definitions or attempts to define conscience and equity even today. Okay, there have been some attempts to define, or there were some attempts in that pre-modern period to define what we mean by conscience. And one of the prevailing concepts that featured in that literature is the idea of conscience as expressing this thing called synderesis. Synderesis is a concept that we can trace all the way back to the writings of St. Jerome in the 5th century. And there's various different definitions. This is a definition from a modern dictionary. But all of the definitions seem to align around the idea that synderesis represents an innate capacity within the human being to be able to hear the divine wisdom as to what is in good conscience and what is not. We're able to hear it. That's built into our subjectivity. And it's worth dwelling on the fact that during this time, there was an indistinction, an elision between the idea of conscience and the idea of consciousness. In fact, etymologically, people would argue that they were synonyms during this time. And that's reflected in this idea of synderesis, that simply to be conscious, is to be confronted by your conscience, to be able to listen to the voice of divine wisdom. Now, this began to change around the 17th century, and it largely changed because of the seismic changes that were happening in society at that time. The Reformation, the post-Reformation period, the emergence of the modern state, the emergence of early capitalism, the idea of the individual as the building block of modern society, and conscience adapted to that. And we see references to conscience in equity cases changing in their sort of syntax, in their rhetorical force. We find that the conscience is being transformed from the idea of being able to listen to this sort of divine wisdom to conscience being an introspective faculty of the individual, their personal responsibility, their own moral integrity, their ability to reflect and introspect on that. The writer Dennis Klink has described this shift in the idea of conscience as being a shift from a canonist model of conscience to a Protestant model of conscience, focused on an individual relationship with God in one's faith. Okay, so let's have a look at some cases, see how this language changed during this period, how the rhetoric changed. So these are a few cases from the early 17th century. We see a reference to something being against conscience, something being in good conscience, the rules of conscience. That's still referring to conscience as a sort of an objective idea, an objective moral set of ideas that we have an obligation to listen to. But then we see this focus on the individual, the personal ability to reflect on one's conscience. So we see references to someone being obliged in conscience, having their conscience bound, their individual personal conscience bound, their personal conscience is affected, thinking back to that example with the mistaken bank payment. We find references to someone having an ill conscience. The duty of equity is to reform their conscience. These, as I said, this particular type of vocabulary survives even till today. The idea of a personal conscience, one's individual conscience being affected and bound, and that's the source of the obligation. So equity changed, conscience changed in terms of its place in law around this time. And it's obviously still doing something. It's sort of modulated a bit, but it's still doing something. And the point of this sort of digression into a bit of legal history is partly to simply illustrate that sort of change for the sake of understanding it. But it's also to show how conscience endures as an idea. It adapts, it survives. And whether it's a general capacity to hear the moral truth of divine wisdom or an introspective capacity to know the moral truth of oneself, conscience is still animating equity in that form. What I would also suggest is that this type of sort of syntax around conscience implies a splitting of the subject. Again, thinking back to Homer Simpson with different versions of himself on his shoulders, that the subject is sort of, there's a duality there, there's a tension, a contradiction within the subject there. And this idea of the splitting of the subject, the way in which the subject is sort of in torsion with itself, runs through a much wider history of ideas, whether it's in philosophy, psychoanalysis, all sorts of different areas. We could talk about all sorts of theorists who are trying to grapple with this idea, try to understand it. We could talk about Kant, Freud, Nietzsche. Thankfully, I don't have time to do that because I have Timo, a philosophy colleague here, and I don't want him to ask me a difficult question about any of those things. But I will mention a particular theorist. And this is someone who's also grappled with the idea of the subject being split, and also has thought about the way in which conscience is part of that splitting of the subject. And that's the idea of conscience that we find in the writings of Michel Foucault. So, Foucault, I'm sure some of you will be familiar with his work, some of you won't. But just as a sort of very brief summary, one of the many things he argued was that power isn't something that just presses down on us, like in an authoritarian state. It's not just a sort of a monolithic expression of power down onto the subject. Instead, there's other ways in which power operates, in that it insinuates itself into our subjectivity. It insinuates itself into the way in which we understand ourselves and our duties and our relationships with other people in ways that we might not necessarily be able to consciously understand. So this is a quote, fairly famous quote, I think. So he's talking about a form of power that cannot be exercised without knowing the insides of people's minds, without exploring their souls, without making them reveal their innermost secrets. It implies knowledge of the conscience and an ability to direct it. So that's quite a critical view of conscience. Sort of conscience is a form of power. Conscience is something that can be directed and manipulated in the way in which the subject understands itself and, of course, its obligations. So, final set of points that I want to make. We don't have to accept Foucault's view. There's various different theoretical ways of critiquing conscience, but that's one that I wanted to dwell on. What's the point of all of this? Is this just sort of scholastic discussion around sort of various theoretical ideas, as interesting as they are? Well, it is that, but it's also something that I want to link back to the modern law of equity. and to think about a particular area of equity in which I suggest you might be able to draw a link with this idea that the conscience can be directed, that it's a form of power. So, as colleagues that teach equity, such as Francis there, I'm sure there might be others around, they'll know that one of the areas that equity deals with is adjudicating disputes about the family home. It's not an uncommon situation that an unmarried couple, they're in a relationship, they buy a house together. They might have contributed different amounts to the deposit. They might have contributed different amounts to the mortgage payments or the household expenses, the indirect costs of having a house. And of course, just to also add, it's possible that they didn't actually explicitly agree in advance how much of the house they each own. Is it a 50-50 split? Or should there be an unequal split? It's a fairly common problem that equity has the duty to resolve. So if there isn't evidence of what they agreed, what they intended, then equity has the job of trying to work out what they did intend, but they didn't express it, they didn't write it down, or even what they should have intended. Equity tries to look into the mind of the individuals in this particular situation. Equity can make inferences about what people intended. So even though it's not clear from the evidence that they intended a particular split or a particular division of the property, the judge can infer from other evidence what they think the person intended, again, to try to look into their mind. And this involves various presumptions, normative presumptions. So, for example, in a recent leading case, it was made clear that there is a strong presumption that a couple in a relationship should have a 50-50 split because relationships, and I quote, represent a joint emotional and economic commitment. Now, that is a normative idea, and that may well reflect the prevailing sort of mores of society, but it is a normative claim, and it is at least open to discussion. In addition to inferring, courts can also impute intentions. Imputing something is something a step further. You're not trying to work out what someone actually intended. You're projecting an idea of what they should have intended. So again, there's this sort of tension between the normative ideas that law is trying to express and the idea of the autonomy of the individual, what was actually going on in their mind. So, concluding point in the last minute or so. I'm going to be a little bit ambivalent in my conclusion. I think there are interesting ways in which we can interpret this as a positive thing. It's good that law has this inbuilt component that requires, or at least purports to require, some sort of internal ethical reflection. We could also say that this is quite good in that it allows for the law to adapt to changes in social moods, that conscience might be something like an empty signifier in which the presumptions, the ideas of how we should behave are injected into the jurisprudence of equity. Or we could look at it critically. We could think about this as an example of ideology, and perhaps the most profound, or one of the most profound ideas of ideology in that these normative ideas are perceived to come from within the self. Homer Simpson, again, they're little versions of himself. Who knows what they're telling him? Who knows where those little voices came from? But for him, it's himself telling himself what he should do, if that makes sense. So, there we are. I think that's... I'm not going to sort of add a polemical conclusion there. I just want to sort of end with that as food for thought, and hopefully that's been interesting in terms of thinking about how conscience obligates us and what that means. Thank you.
Thank you very much, Matthew. My name is Stavroula Karapapa. I am acting faculty dean of research in the Faculty of Arts and Humanities and a professor in the School of Law. I would like to thank our professors for their enlightening and thought-provoking presentations this evening, and would like to offer you the opportunity to ask a few questions, perhaps one for each one of our professors. Yes, Tara.
Hi, so first, congratulations to both of you. I thought they were both very entertaining and interesting. Onyeka, I obviously have a three-part question for you. So, you mentioned Leonard versus PepsiCo and Kasky versus Nike, and what I get from both of those is a reinforcement of corporate power in the face of the law. The law is really intended to protect that corporate power, and when the law pushes back against the corporate power, it fundamentally, the law is reformed to, again, incorporate and protect corporate power. So when you made your proposal, I kept thinking, I love your proposal. I want your proposal to be reality. And also, how do we get there? Because some of the CSR laws that we do have fundamentally are laws that, again, enhance corporate power. So India's law allows corporations to decide for themselves where they'll invest their money in CSR. So again, giving corporations more power over society and over society's interests. So in a practical form, how do you do this? And I guess the second part of that question is really, does a CSR approach to this, as opposed to a business and human rights approach, does a CSR approach fundamentally just enhance corporate power over the rest of society?
Thank you, Tara. I think in the first place, you have to see law, public policy, legal policy at two levels: the substance, the enforcement, or even three levels: the enforcement and under enforcement, who enforces. So if we focus on the substance, the point is the substance is often a compromise. And the compromise, whether we like it or not, most of us in this room are lawyers. The compromise is usually the very minimum standards, the lowest standards. Okay? But at the same time, the reality is the minimum standards are not enforced in practice. If you use Modern Slavery Act 2015, when it came out, Theresa May was Home Secretary. She talked about it. As Prime Minister, she was talking about it as the big thing she's done. How corporations are being held to account, transparency provisions. But somewhere there, you will see that there is little in terms of obligations. But not just that. What happens with the little you've imposed on the businesses concerned? No room for enforcement. So my point is, the ideal position is to go for very good substantive provisions enforced by everyone effectively, but we are unlikely to get to that. But the little we have should be enforced. And how do you do that? Stakeholders, private stakeholders demanding for a right to be involved in the enforcement process. And secondly, having some sort of general standard that statements matter. So whether it is a statement about, I am good, or my product, the same way you say your product is good and it matters, should also mean when you say you're good or you're doing A or B, it should also matter and should be enforced. If the public authority is not willing to do so, then there should be room for private stakeholders. And that is our job as researchers. That's, in my view, to highlight that particular issue, to say, look, it doesn't work, the present system, that one, the substance is low, two, no enforcement, but at least give private stakeholders opportunity to enforce. There's another thing about enforcement. That power to enforce can actually help to drive up standards. Because in terms, look at Nike case, as part of the settlement, they went beyond what was expected. They agreed that, okay, we are going to have independent monitoring, we are going to fund so and so, and all sorts of things going on because there was room for that private enforcement. So, yes, our job is there because the reality is different from the ideal. And that's why we are doing it. Otherwise, if the ideal is real, then we shouldn't be talking about what we're talking about improving the law and improving the substance and enforcement process. Thank you.
Thank you very much, Onyeka. Question for Professor Stone? Yeah. Jeff?
Matt, this is for you that I'm pretty certain Onyeka might want to follow up. I find no problem when we're talking about human beings in applying conscience. How do you attribute conscience when we're talking about non-humans, when we're talking about equity being used with respect to companies? Equity being used with regard to states, because equity is a general principle of international law. How do you use conscience with the non-human?
Yeah, thank you, Jeff. So just to summarise, you're saying that there's this problem that conscience isn't just imposed on human beings, it's imposed on corporations and so on. I think that's a really good point. I suppose, obviously, well, I don't know. Would it be too much to say that corporations don't have a conscience? Maybe that's a question for Onyeka. But yeah, I'd absolutely agree. So I suppose my answer is that what I'm interested in is where that's come from. So I absolutely agree it's artificial. And I think, my interest in this isn't to try to assert or even investigate whether there is such thing as a conscience in a kind of a metaphysical sense. And I think that part of my interest in this is how there seems to be such a dissonance between the flowery language of conscience that we find in the case law and the hard-nosed reality of how it's applied and so on. So yes, I absolutely take your point that that there are areas in which that artifice is undeniable. But my curiosity is about where that's come from. So it's not that, for me, it's not a problem that corporations don't have a conscience. It's an issue of where that structure of obligation has come from. But I think that's a really interesting point in that there is a further sort of complication or complexity or contradiction here in that we have a certain set of rules that have been derived from conscience that are sort of based in this jurisprudence that I've been talking about. But clearly that's now sort of completely divorced from any sort of literal understanding or even figurative understanding of there actually being a conscience. So my answer is that I'm more interested in what conscience is doing rather than whether it's real, whether we can attribute it to certain entities like that. I don't know if Onyeka, you wanted to respond as well.
All right, thank you. Thank you, Jeff. When I teach company law to students in order to explain the concept of a company as an artificial entity, I tried to print a copy of a certificate of incorporation and say, this is the company, this piece of paper. This piece of paper, that's the company, the name, and, students will be looking at me and I said, can this piece of paper do something? No. But we are told that this piece of paper can act, can take decisions, has taken decisions, far-reaching decisions, borrow money, billions, invest, this piece of paper. So what does that mean? So the reality is, if you want to find the corporate conscience, it is easy. You look for the people behind the company. You aggregate the conscience of the people behind the company. Classic example, we've heard about technology companies. You hear about Facebook. Facebook, danger, online harm and all that. And if you want to bring Facebook, immediately, what goes on in your mind? Mark Zuckerberg. Bring him and talk about what Facebook is doing. Why is that so? Because the conscience of Facebook can be attributed to Mark Zuckerberg. And recently, every time I go in to listen to the news or whatever, Twitter, I'm on Twitter, I don't tweet, but you can always see Elon Musk on Twitter. If you want to find out the conscience of Twitter now, what do? Not anyone else. Get Elon Musk in the room and ask him, is this good or bad? What do you think about this? What does what does the company think? And you find it. So the idea that you can't find the conscience sometimes is used to say that companies cannot owe social responsibility because they don't have a conscience, but they do. Thank you.
I would like to thank once again our professors. Our next professorial inaugural lectures will take place on Wednesday, the 10th of May, and would be delighted if you would be able to join us. Professor Ilaria Bonkori from Essex Pathways and Professor Diana Boulen-Presciuti from the School of Philosophy and Art History will be speaking about their research. It only remains for me to bring this event to a close. Thank you all so much for attending, both online and in person, and I hope you will now join us at the drink reception in the Winter Garden. Thank you.